Good morning, Acting Chief Justice. All the parties are online. Can I ask the registrar clerk to call the case, please, with your leave? You're on mute, Acting Chief Justice.
I'm sorry, I didn't realize I had muted myself. Yes, please call the matter, registrar.
Good morning. I am the registrar clerk for this hearing. Acting Chief Justice and Justice of the Constitutional Court, all counsel are online. I call the matter of Desta Abore versus Minister of Home Affairs and another for hearing. Counsel are now invited to place themselves on record. Please note further that this hearing is being recorded.
Morning, Acting Chief Justice. And
yes,
Justice.
Good morning.
Acting Chief Justice, I appear for the applicant in the matter. Surname is Vobi. I appear with Advocate Maziba and Advocate Nase.
Thank you, Mr. Vobi.
Good morning, Acting Chief Justice and
Good morning.
Justices. I'm appearing on behalf of the respondents, and it's Nobanda appearing with my learned junior, Advocate Mutige.
Thank you very much, Ms. Nobanda. Mr. Vobi.
Yes, Acting Chief Justice.
Yes, I'm going to give you 45 minutes to present your oral argument. I will give you the first 10 minutes as 10 minutes during which we will not interrupt you as you highlight the main points that you want to highlight or present your argument. But I also want to say this both to you and to counsel for the respondents. One, that we have read your written submissions, both of you. We know what your submissions are. It's not necessary during oral argument to deal with every point that you have in your written submissions. We will not assume that if you don't include a certain point in your oral argument, it means you have abandoned it. We won't do that. So in addressing us, you will highlight the important points that you want to highlight, but my colleagues and I will be free to ask you questions even on points that you might not have dealt with if they are in your written submissions. So you use the opportunity to address us on what you believe are important points without going through everything that's in your written submissions. So the first 10 minutes, we will not interrupt you. You can start.
Thank you, Acting Chief Justice. In fact, we had structured our heads and have some topics in which I wanted to cover during my address. However, I will, with the interest of time, I will just highlight the purpose of this application, quickly deal with the background, the jurisdiction, the test for granting of leave to appeal, the application for leave to appeal directly to this court, the merits of the appeal, and the two issues which we classified are the issues in dispute, then submissions in relation to what is raised in the respondent's submission, which is the amendments on Refugees Act and the regulations thereof, then the costs. We argue that the purpose of this application is predicated in Rule 12 of this court, which deals with agency, and with and also predicated in Rule 19 of this court, read together with Section 167 3B, which is the direct appeal to this court. We classified the issues that are in dispute to be two, which we have structured those issues as followed: whether the applicant's detention was unlawful, justifiable under the Immigration Act 13 of 2000, which is the period from the 7th of July 2020 up until the 25th of June 2021. Then the second issue, which we also classified as the issue that is in dispute, whether the applicant is entitled to exercise his right to apply for an asylum in terms of Section 21 of the Refugees Act 30 of 1998. For both issues, we submit that this court and the Supreme Court has provided clarity, which in terms of the remedies, we rely in Section 2, subsection 2 of the Refugees Act and Section 35, 2D of the Constitution of the Republic of South Africa, Act 108 of 1996. On facts, I will just submit as follows. The applicant is an Ethiopian national who fled his country of origin in October 2019 and arrived in South Africa in mid-December 2019. And the reason he fled his country, it's because of persecution based on his political affiliation, the terrorism, the torture and killing of his members by the ruling party. The applicant had made a decision to leave his country based on his constant fear of his life at the hands of the ruling party. The applicant, when he arrived in South Africa, he stayed in Eshowe, which in January and February 2020, he made attempts to apply for an asylum, which both attempts that he made were unsuccessful. Then in March, the offices of Home Affairs were closed. Then he couldn't pursue his intention further. Then in June, which is on the 8th of June, that's when he encountered the officials and he was arrested for being illegal in the country, and he was charged in terms of Section 49 of the Immigration Act. Then, as it appears on the documents that are filed in this court, that on the 7th of July, he pleaded guilty to the offense that he was charged with. He was given an imprisonment for 50 days with an option of a fine of 1,500. As it appears on the papers that are filed in this court, that on the same day which he pleaded guilty, that he paid a fine of 1,500. His countrymen paid that money. Then on the 9th of July, he brought an agent application in Durban, which he sought among to be released from detention, to interdict the respondents from deporting or arresting him, or to remove him from the jurisdiction of Durban, which is in KwaZulu-Natal. Then in addition to that, he sought 2 mandamus orders that the respondents should do all what is necessary to assist him to apply for an asylum and to be issued with an asylum seeker's permit. The application was had on the 21st of July, which 4 orders were granted. Those orders are that he should not be removed from the jurisdiction of KwaZulu-Natal, and an interdict against, if the court may bear with me just to go to the correct document in our reply, because that's where we attached this order from Durban. The orders that were granted in Durban are as follows: that the 1st, 2nd, 3rd, and 4th respondents are directed not to remove the applicant from the jurisdiction of KwaZulu-Natal, Durban. The 1st, 2nd, 3rd, and 4th respondents be and are hereby interdicted, restrained from deporting the applicant to Ethiopia. Then a rule was issued in respect of 4.2 and 4.4, which read as follows: the 2nd respondent, alternatively the 3rd respondent, alternatively the 4th respondents be and hereby directed to present himself on 31 July or any subsequent days that may be requested to attend to the refugees administered by the 2nd and 3rd respondents to apply for an asylum in terms of Section 21 of the Refugees Act. Then 4.4, the 2nd and 3rd respondents be and hereby directed to do all things necessary to assist the applicant in applying for a temporal asylum seeker's permit, and forthwith accept, consider, and process such application to issue the applicant with a temporal asylum seeker's permit, as well as to afford the applicant all the necessary protection in terms of the Refugees Act. In terms of these orders that were granted in Durban, as it appears on documents, there is no compliance which was made to the effect of 4.2 and 4.4. Then it appears on the documents that are filed in court that on the 27th of January, a rule NISA which was issued on the 21 was finally discharged. Then on the 8th of February, the applicant was, the 8th of February 2021, the applicant was transferred from KwaZulu-Natal to Elindela in Johannesburg, which he was then issued with a notice of deportation in terms of Section 34(1) of the Immigration Act. Then on the 1st of March 2021, the applicant's detention was then extended for a period of 90 days pending his deportation. Then in March, the applicant approached the Johannesburg High Court to seek an interdict, a release from detention, to declare his detention to be unlawful, and to ask that the applicant to be afforded an opportunity to apply, which application served before Judge Twala. On the 29th of March, the application was dismissed with costs, which is the basis we are before this court. Then,
your 10 minutes, Mr. Fobi, your 10 minutes is up. So from now on, you may expect colleagues to interrupt you, but you may proceed.
Thank you, Acting Chief Justice. Then what has happened after, on the 25th of June, the applicant was released from detention, which he was issued with a notice of depart on his own in terms of Section 30 of the Immigration Act. We have then brought an urgent application in the High Court to interdict the implementation of that notice pending the finalization of this matter. The matter served before Judge Windel, which was on the 13th of July, and the order was granted in the applicant's favor. The applicant is now out. However, what is left is that he must be given an opportunity to apply for an asylum. Then I move to the jurisdiction. We submit that this court—
Mr. Vobi, a bit of advice for the future. 45 minutes is a very short time. You've wasted the entire 10 minutes because you are telling us a narrative that we are aware of instead of arguing your case. Just advice for the future.
Thank you, Justice Malanga.
Mr. Vobi, can you just help me with the dates? Somewhere in the record, it stated that the applicant entered the country illegally in 2017. Then we have a date of 2019. Then there's another date, I think referred to as sometime in 2020. What is the correct date? When did he enter this country?
Justice Mhlanhla, the applicant entered this country in mid-December 2019.
And when did he make known his intention to apply for asylum?
As it appears on our papers, he made his intention to apply when he was arrested. However, he was not given an opportunity to pursue his intention. Then in terms of the letter of demand, which was issued before the application was issued in the Johannesburg High Court, again, he evinced his intention to apply. Then thirdly, when the matter was brought in the Johannesburg High Court, again, he evinced his intention to apply. So I would say, to summarize on this point, that about 3 times in which he has evinced his intention to apply.
The first one when he was arrested?
Yes, which was on the which was on the 8th of June. Then the second time, if the court may bear with me just to get the reference in relation to the letter of demand, to get the date in which the letter of demand was sent to the respondents. Justice Mhlanhla, the letter of demand was delivered on the 1st of March 2021.
My sister, if you don't mind, if I could interject, it relates to the dates that you had asked Mr. Mvobi about, Justice Mhlanhla.
Yes.
May I? Mr. Mvobi, in his affidavit in the High Court, the applicant says he left Ethiopia in January 2020. In your submissions, in your 10-minute submissions that you had uninterrupted, you said he arrived in South Africa in December 2019. In response to my sister, Justice Mhlanhla, you also gave a date in 2019. His affidavit, it's volume 3. And if I understand the pagination correctly, it's R42 and paragraph 7.14.
Yes, Justice Theron, in respect of that submission, it's the submission that was made in the Durban application, which we were not part. And when we brought the application in Durban, in fact, in Johannesburg High Court, we were not aware about. In fact, we provide reasons in our reply as to what transpired in respect of that application. However, in page 41 of the founding affidavit, which was submitted in the Johannesburg High Court, in particular in paragraph 12, that's when he says, I fled Ethiopia in October 2019, and I arrived in the Republic of South Africa to seek an asylum in mid-December 2019.
Mr. Vobi, the difficulty is that those are not submissions. Those are affidavits under oath in which the applicant describes or says when he arrived in the country. He would need to explain why in the Durban High Court he said he left Ethiopia in January 2020. Is there an explanation on the papers or from the applicant about the discrepancy in the dates? Because in the documents, the affidavits that you've referred us to now in the Johannesburg High Court, that's paragraph 14, he says, in January 2020, I went to the refugees offices in Durban. Now, one of these statements must be incorrect.
Justice Theron, as I have indicated during my submissions in relation to the facts, that he made 2 attempts before his arrest. The first attempt was in January 2020, and the second attempt was in February, which was also in 2020. Then on the 8th of June, he was
Mr. Bobby, I'm
arrested.
sorry to interrupt you. I don't think I've made myself very clear. The discrepancies that I'm referring to is the dates when he says he either left Ethiopia or arrived in South Africa. The applicant would need to give an explanation as to why in the Durban High Court, in paragraph 7.14 of his affidavit, he says he left Ethiopia in the 2nd week in January 2020. In the Johannesburg High Court, in paragraph 14 on page 41 that you've referred us to, he says in January 2020, he went to the refugees offices in Durban. Now, both those statements cannot be correct. He could not have left Ethiopia in the 2nd week in January 2020, and as well in January 2020 have gone to the Durban offices. And unless, of course, he left Ethiopia in the 2nd week in January 2020, and thereafter, still in January 2020, went to the refugees office.
Yes, Justice Theron, our submissions in respect of this issue is that he arrived in the country in mid-December 2019. Then after he moved to Eshowe, KwaZulu-Natal in January, that's when he made his first attempt to apply for an asylum, which he could not succeed because of the queue. Then the second attempt that he made, it was in February, which he could not succeed again due to the long queues in Durban Refugees Reception Office. Then he was arrested on the 8th of June in 2020. That's our submission. In respect of what transpired in the Durban application, with respect, we have provided the basis in which that application was not even provided in the High Court when the matter served before Judge Twala, even when we brought this application before this court, because it's a document that we attach in our reply.
Thank you, my sister, I'm sorry for the interruption.
Thank you, Justice Theron.
Can I ask you a question on the issue of the detention, Mr. Vobi? What was the effect in law of the discharge of the rule nisi in the circumstances in which it happened, on the issue of the lawfulness or otherwise of the detention.
Thank you, Acting Chief Justice. In fact, to deal with this point, I will start from the 7th of July, as it appears on the papers, that is the date which he paid, or his countrymen paid the fine for him. That's the date which he was eligible to be released from detention. So even the period in which—
I'm sorry, Mr. Fobi. My understanding of the papers was that the issue of the payment was not before the High Court in the matter that is before us. Is that not correct?
That's correct, Acting Chief Justice. However, on the same point, what we argued before the High Court was—
No, let's finish on this one. Let's finish on this one. Why would you be entitled in an appeal to place before us that evidence that was not before the High Court in circumstances where we would be sitting on appeal to decide whether the High Court's decision was right or wrong? Aren't we supposed to decide that question on the same record and on the same evidence that the High Court had before it?
Thank you, Acting Chief Justice. In fact, to respond to the question that is being posed to me, our argument will be limited to the extent of what we argued in the High Court, which, when we argued this point, we were not aware that he had paid a fine. However, because the charge sheet was before the court, and in terms of the charge sheet, his period of imprisonment was for a period of 50 days. We argued that from October, in fact, from August, in which his period has run out in terms of his sentence, he ought to have been released. We then argued that from that period up until he was dealt with in terms of the Immigration Act on the 8th of January, in fact, on the 8th of February 2021, that his detention is unlawful. That was our argument, and is the argument that we are still pursuing before this court, that there is a period which is not accounted for from the day his sentence ran out up until the date in which he was released. In fact, even the detention which took place on the 8th of February, we submit that that detention is unlawful because it arises from an unlawful act, and that the respondents cannot seek to—
Mr. Fobi, I'm sorry, I'm interrupting you. I'm doing so because I see you don't have a lot of time left, and I do want you to address important issues. Let's go back to my question. What was the effect in law of the discharge of the rule in the circumstances in which it happened? I ask this question because my understanding is that in those proceedings, the applicant challenged the lawfulness or otherwise of his detention, isn't it?
That's correct, Acting Chief Justice.
So that was an issue between the parties. If the rule had been confirmed, that would have meant that the court would have found in his favor. And if the rule is discharged, can you subsequently raise the same issue? Can the applicant subsequently raise the same issue?
Acting Chief Justice, in terms of my understanding of the proceedings that were in Durban, because that's when the rule was discharged on the 27th of January. In terms of that application, if, for example, the respondents had complied with the rule that was issued, he ought to have been released after he has been issued with an Asylum seeker's permit, which will be by operation of law. And the issue of the detention at that stage, he did not go to court to challenge his detention. He went to court on the basis to ask to be afforded an opportunity to apply for an asylum. Then when we brought an application in Johannesburg, we brought an application based on 2 grounds, on the basis that he wants to apply for an asylum, and that secondly, that his detention is unlawful, relying from the date his sentence ran out up until the day we brought an application, because we argued that for that entire period, it's not accounted for.
Okay, proceed.
Thank you, Acting Chief Justice. The other important issue which I would like to touch on is jurisdiction. We submitted that this court has jurisdiction to entertain this matter in terms of Section 167, 3B, Roman figure 1 and 2. We submit so on the basis that this matter engages or raises an important constitutional issue, which is the right to freedom and security in terms of Section 12 of the Constitution. We also rely from the judgment of this court, which is the judgment of it's J.E. Mahlangu and others. If the court may bear with me just to get the correct citation.
Mr. Vobi, I didn't understand.
Acting Chief Justice, you're on mute.
Okay, I'm sorry, Mr. Vobi. I'm saying I didn't understand the respondents to be taking issue with the jurisdiction of the court. You might be well advised not to, you might be well advised to spend your time, the rest of your time on other issues.
Mr. Vobi?
The respondent may have raised the issue of whether it's in the interest of justice for you to bypass the Supreme Court of Appeal, but I didn't understand them to take issue on the issue of jurisdiction. And I don't think that they would.
In fact, I will just move to deal with the issue of the interest of justice, which I will submit that the interest of justice supports the leave to be granted to this court.
Okay, all right. Just before, I think Justice Theron wanted to ask something or say something.
Yes,
Justice Theron.
Thank you, Acting Chief Justice. Following your lead, Mr. Vobi, perhaps you can address us on the Refugee Act was amended. You can perhaps address us on whether the amended Act and regulations or the unamended Act regulations apply, and whether there's a difference if either one of those 2 acts apply, or there's no difference. I think that might be important for your case.
Thank you, Judge Theron. In fact, in our heads of argument, we submit that the new regulations and the amendment on Section 21 of the Refugees Act are not applicable in this matter. We submit so based on the following reasons. One, that was not raised before the High Court. Number 2, in terms of the amendment on the Refugees Act and the amendments on the regulations, it doesn't provide that the regulations, they have a retrospective effect. In terms of our case, we argue that the applicant arrived in 2019. And when he arrived, the regulations and the amendment in the Refugees Act were not law. Therefore, there is no way in which he could have complied with those amendments. In addition to that, we also rely from a passage from the judgment of this court in relation to the effect of a retrospective effect of the amendment, which is the judgment of Chisusi and others versus the Director General, Department of Home Affairs, it's a 2020 judgment, ZACC 20. In that judgment, we rely in page 33, paragraph 71, and in page 34, in paragraph 73. In fact, in paragraph 73, it says, consequently, an interpretation that favors the prospective only operation in this instance effectively abolishes the existing rights. The principle underlying the presumption against the retrospectivity is that vested rights which were acquired under existing laws may not be taken away by a new law. This is fundamental to the values of fairness and justice. Based on that paragraph and in view of when the applicant has arrived in the country, we submit that the regulations and the amendment on the refugees should not apply in the applicant's case. In fact, while I'm dealing with this issue, there is also a judgment which has been referred, which judgment seeks to address the applicability of the amendment, which is the judgment of Desta, which is the judgment that my learned friends have relied on to argue that in terms of that judgment, we ought not to succeed in this appeal. I submit that one, the judgment of Esther Muale, it's not binding to this court. And number two, there is a judgment from Johannesburg High Court, which is part of the judgment that we have submitted this morning. It's a judgment of Obina Odwen Ayechu and Minister of Home Affairs, which judgment deal in particular with the judgment from the Eastern Cape. And in terms of this judgment, de Villiers AJ from paragraph 34, in fact, yeah, it's from paragraph 34, where he deals with the judgment of Muhwale, and on paragraph 38, 39, 41, 42, 43, 44, up until paragraph 46. In fact, just to summarize what is provided in this judgment, Justice de Villiers, he disagrees with the judgment from the Eastern Cape on the basis that the applicant in the matter that was in Eastern Cape, he ought to have been given an opportunity to apply, even though the issue of the new regulations were raised, that they were not applicable. Then he also deals with the second issue, which was raised, that the applicant was prohibited to apply for an asylum on the basis that in terms of Section 4 of the Refugees Act, he was prohibited because when he was arrested, he was sentenced without an option of a fine. Then he says the only body which can decide whether an application for an asylum should be granted is a refugee reception office only, but not the court. Therefore, on that matter, he find that it was incorrect for the court to apply the new regulations and to deny the applicant an opportunity to apply. In
Mr.
fact,
Vopi, may I ask you an antecedent question to the one you're dealing with now? And that is the question of direct leave to appeal. What do you say about the submissions of the respondents that since this is a new legislation which appears or purports to impact on the Ruta judgment of this court, the matter should have gone to the SCA on an urgent basis in terms of their rules, where the president could set it on an earlier basis. What do you say of those submissions that it was better for this court to have the benefit of the views of the SCA, where we're dealing with legislation which purports to impact dramatically on a judgment of this court, namely Ruta?
Thanks, Justice Manjat. In fact, our submission in relation to that proposition.
It is Majid, Mr. Bobby.
Thanks, Justice Manjat. Our submission in relation to that proposition, we submit that that was not the argument when the matter served before Twala. Therefore, there is no way that we would have anticipated that they will raise the issue of the new regulations or amendment on the Refugees Act. In fact, even on their answering affidavit in this court, they did not rely on the new regulations. It's an argument that came on the written submissions. In addition to that, because we brought this matter on an urgent basis, in fact, even on the judgment of the High Court in paragraph 2, Justice Twala agrees that the matter is urgent because it involves the right to liberty. We submit that we are entitled to come to this court. In fact, in terms of the requirements to approach this court directly, to appeal to this court directly, we submit that in terms of the test of interest of justice, we meet that test in that the matter is urgent. It still involves the right to liberty. And when we brought an application, the applicant was in detention. We brought an application in order to deal with the matter expeditiously before he could be deported to his country of origin, which a principle of non-refoulement, we submit that kicks in. And based on that principle and the judgment of Ruta, we were entitled to come to this court.
Yes, thank you.
Mr. Bobby, sorry, ACJ, you may proceed.
Yes,
ACJ.
continue. Can continue.
Thank you, ACJ. Mr. Bobby.
Yes, Justice.
I know that it may seem like I am taking you back to the debate you had with my sister, Nhlanhla and Theron, concerning the dates, but they concern me. They touch on the application or the applicability of the amendments to the case of your client. Am I correct in thinking that the amendments were effected to the Refugees Act on the 1st of January 2020?
That's correct, Justice Shikri.
Now, if there is this, there are these discrepancies about the date on which your client came into the country, how do we then determine whether the amendments affect him or not? What I'm trying to say is, you're saying that he arrived in December, a month before these amendments were effected, but there's discrepancies. There's even a date that dates back to 2017. And this is the problem that I have. How can we know that, in fact, definitely, when these amendments came into effect, he was not, or he had not entered this country?
Yes, Justice Shikri. In fact, my response to the question that you just posed is that our argument, we rely on the basis that he arrived in the country in mid-December. However, even if the court, because as it appears on the application that was in Durban, it seemed to suggest that he arrived in 2020, which the regulations will be applicable to him. However, in terms of the judgment of de Villiers AJ, you will be entitled to release the applicant despite of these discrepancies, because the regulations do not provide that the applicant who evinces his intention should not be released. In fact, There's a judgment from the SCA, which is the judgment of, if I'm not mistaken, I think the judgment of Asylum, which dealt with the issue of discrepancies. In terms of that judgment, which they were
Mr.
conducted.
Vobi, I'm sorry to interrupt. I think the question that my sister Chikwe has asked is an important one. And it's not really focusing on the discrepancies and whether relief can be granted despite the discrepancies. I hope you don't mind, my sister. I'm just trying to clarify because it is important that I think what we need to know is which act is going to apply. How do we determine which act and which regulations apply? Because we have to determine which regime will govern the applicant. Is it the old regime, the unamended regime, or is it the amended regime? Or are you saying it does not matter?
Justice Theron, our submission in relation to this question are twofold. We submit that when we argue the matter in the High Court, we argued the matter on the basis that the applicant had arrived in the country in 2019, which in terms of his arrival, she should be dealt with in terms of the old regulations, irrespective of whether he arrived in mid-December or in 2017. However, in the event the court, because there's an application that was brought in Durban, which he deposed under oath that he had arrived in 2020, that even if the new regulations have to apply in his case, in terms of the judgment of de Villiers, which dealt with the applicability of the new regulations, he is still entitled to be released. And to be
of de Villiers AJ, Mr. Vobi, not of de Villiers.
My apologies, Acting Chief Justice. Thank you.
What was your answer to the question whether the amendments render inapplicable any of the principles on which this court's judgment was based in Ruta?
Acting Chief Justice, my submission in relation to the question was that our answer is twofold. When the matter was dealt in the High Court and when we brought this appeal before this court, we brought this appeal on the basis that he should be dealt with in terms of the old regulations. However, even if this court accepts, because it's under oath, that he arrived in 2020 and that the new regulations and the amendment on the Refugees Act should be applicable in his case, he is still entitled to be released in terms of the judgment of de Villiers AJ.
Okay, that didn't really answer my question, but it's fine. Your time is up, unless there are colleagues who still have some questions.
If I could have a final question, please.
Yeah.
Mr. Vobi, I understand your reliance on the judgment that you've referred us to this morning. If you were to refer or have regard to the amended act and the unamended act, would your answer still be the same? Would you be able to still say to this court, justices, leaving aside the date when the applicant came to this court, his rights remain the same? Are you able to refer us to the position under the unamended act and the position under the amended act to drive home that point?
Thank you, Justice Theron. To answer the question, I will submit that his rights are still the same in terms of the old regulation, which is a regulation 2 sub 2, which deals with the principle of non-refoulement when one raises an intention to apply, in that he must be given an opportunity. Even in terms of the new amendments, as much as there are now requirements in that in terms of Section 21, he must present himself at the port of entry within 5 days to be issued with a permit in terms of Section 23. But when he goes to court, or if he goes to the offices of Home Affairs, he needs to provide reasons as to why he has entered the country illegally. When he appears in court, he needs to satisfy the court that he has good reasons for his failure to comply with Section 21 and Regulation 8, which I will submit that in terms of what he said in the High Court in paragraph, in particular in High Court Johannesburg in paragraph 12, 14, 15, there will be a case in which a good cause would have been shown upon which he will be entitled to be released in terms of Regulation 8.4.
Mr. Vobi, I'm sorry to interrupt you, but I would have expected you in response to my question also to refer and to rely on Section 2 of the Refugee Act.
Section 2.
I thought I've started with Section 2 when I was responding to the question.
Okay.
No, you refer to regulations. You refer to regulation because, and you say regulation this, and I'm sorry, my sister, I was listening to you quite closely as well. I thought you would just go straight to Section 2 because Section 2 actually encapsulates the principle of non-refoulement. That's where it is. And it refers in so many words to the fact that whatever this act says, so Section 2 cuts across the very act that we are dealing with. It says you should not act contrary to the principle of non-refoulement. That I would have thought would have been your best answer. Sorry, my sister.
Oh, that's fine. Thank you. Thank you. Yeah, I also was surprised when you referred to the regulations. But this is definitely my last question, Mr. Vobi.
I guess Mr. Vobi will say, I embrace all of that.
Yes, Acting Chief Justice. In fact, that's what I meant to say, but I said instead of the act.
Yes. This is definitely my last question, Acting Chief Justice.
That's fine, yes.
Mr. Vobi, the applicant asked for an order declaring that his detention was unlawful. Is the applicant's case that the entire period of his detention was unlawful, or that certain periods was unlawful?
Justice Theron, as I have indicated that when we argued the matter before the High Court, because of the nature of the application being a habeas corpus, we submitted that his detention is unlawful. Then we called upon the respondent to come and justify his detention. So when we presented that argument, we were referring to the entire period.
Thank you, Mr. Vobi. Thank you, Acting Chief Justice.
Thanks, Justice Theron.
It looks like there are no colleagues who still have questions. Thank you, Mr. Vobi. Ms. Nobanda. Ms. Nobanda.
Yes, thank you, Acting Chief Justice.
Yes, I confirm that you will have 45 minutes, and I confirm that you said you are happy to be interrupted from the beginning if my colleagues and I wish to ask you questions as you proceed. You may proceed.
Yes, thank you, Acting Chief Justice.
Ms. Nobanda.
Yes, Justice.
Let's start right at Section 2. Does any of this detail, the intricacies, the narratives and all, do any of those matter in the face of Section 2? As I indicated prompted of course by my sister Justice Theron, as I indicated to Mr. Vobi, That section actually encapsulates the principle of non-refoulement. And what's crucial about that section is basically that it says, even regardless of what this act itself says, South Africa should not act contrary to the principle of non-refoulement. Is it not so? Or one, how do you understand section 2? Do I capture it correctly? And then 2, if I understand the position presently, the officials require the applicant to leave, failing which they will deport him. It does not appear as though they are going to consider an application for asylum or refugee status. Now, if that be so, how will they ever know that he does in fact qualify not to be treated contrary to the provisions of section 2? How will they ever know? So basically I'm raising 2 issues with you. One, your understanding of section 2, and then the last question I've just raised.
Thank you, Justice Madlanga. I agree with you with regard to section 2, but there are procedures also put in place because there's a problem with most individuals who are arrested and then they used the former regulation 2 sub 2 for them to be released so that they can apply irrespective of when they came into the country. Now, section 2 does it does protect the genuine applicants for asylum. All that the respondents are saying is now in line with the new the Amendment Act and the regulation. The applicant is not entitled to be released and to apply, but the applicant has to go through the processes as indicated and as set out in the Amended Act, that now there has to be an interview to determine whether the applicant can show good cause on or why he does not have a permit and why he remained in the country. He came and remained in the country illegally, so that only then can after that determination, the applicant be allowed to apply. It is just the procedure that the new act now, the Amended Act and the new regulations bring into place. I don't know if that answers your question, Justice Madlanga.
Factually, where are we now? What is happening right now between the applicant and the I'll just loosely call them the state officials? Where are we? What is happening right now?
From the information that we saw from the applicant's heads of argument, it seemed that the officials wanted to deport the applicant, but there was an interdict, and I believe we haven't had anything. We don't know who was handling the matter, but it was not us from the ones who are dealing with this one now. But it appears that the officials were interdicted from deporting the applicant pending now the finalization of this application. So as far as the little that we are all aware of, the applicant is no longer in detention because the 90 days have lapsed, the extension. So I believe that the respondents are now waiting for the decision of this court on how to deal with the applicant further.
I will leave it at that. Thank you very much, Mr.
Mr.
Justice, I
sorry,
apologize.
yes. Sorry.
Yeah, if I may, just following on from Justice
yes,
Madlanga's question.
I will follow on after that. Thank you.
do you accept that, assuming the new regime applies, a person in the applicant's position is at least entitled to have the interviews which are contemplated by Section 21(1)(b) and Regulation 8.3? We don't need to decide, because that's for a refugee officer to consider whether he shows good cause for being in his position. But is he, at least before he is deported, entitled to have those interviews?
Yes, we totally agree, Justice Rogers, because that is what the Act requires, that there should be that interview.
So can you assist me, because it's not clear to me now how the Immigration Act will interact with the Refugees Act. Under the old regime, a person in Mr. Abore's position, even encountered illegally in South Africa, would have been entitled to the visa under Regulation 2.2. That regulation is no longer there. So on the face of it, we have Mr. Abore lawfully under arrest under the Immigration Act, although he's now been released. Let us consider the position prior to the release of such a person. One has him lawfully under arrest under Section 34, but apparently with an entitlement to go and be interviewed by an immigration officer to try to satisfy Sections 21(1)(b) and Regulation 8.3. What happens to such a person? Is there any provision for him to be released and given some form of a visa, at least to do that much? And if not, is it possible for him to do so while he's in detention?
Justice Rogers, your question actually was decided by that question you're asking. There's a judgment that we only got hold of just a few days ago. I think it was decided on the 26th of July by the Honorable Justice Colapen in the Pretoria Gauteng High Court, and there it's on a similar facts where the applicant sought they sought the release of so that they be given an opportunity to apply. And he was applying the new provisions. He found that the new provisions are applicable in this case. And then he made an order. He said that they were in lawful detention. And I think it reads from, I did actually ask my attorney to forward a copy to the registrar of your court so that the justices can have a look at that case. It's in paragraph 30, I think from 38 to 41.
Mr. Banda, what is the name of the case?
Yes, it's called Shanko Abraham. And I'll just say, and three others, because there were three cases that he decided versus the Minister of Home Affairs. And it's a case number 32620, 32621, 32622/2021. And he deals specifically with this issue. There, he says that the applicants are not entitled to be released from custody as they would have been with the old regulation. But he gave an order that the respondents that should find a way to interview the applicants, whether the applicants should be brought to the offices of the respondents or the immigration officers should visit the applicants in custody so that they could then comply with Section 21(1)(b) and Regulation 8.3. So basically, what Colapen J was saying is there is no longer that entitlement, because then the new regulations, they do not make provision for the release as it was with the regulation 2.2.
And is that the position you adopt and support as correct on behalf of your clients?
Yes, Justice Rogers.
Thank you.
Ms. Nabanda, I'd like to follow up on that because I want to take you through this new legislation, the Act first, Section 21(1)(b), and then the regulation that you rely on, Regulation 8.3. And I can just caution you that I'm also going to refer to Regulation 8.4. But let's start with the Act. Before we read the provisions of the Act, Section 21(1)(b), I want to first establish the following. First, my brother Madlanga Jay has made very clear to you that the principle of non-refoulement in Section 2 of the Refugees Act is paramount. Do you accept that?
Yes, I do.
That follows Article 33 of the Convention. It repeats that article. So it's absolutely paramount, the principle of non-refoulement. Second, do you accept that Ruta in this court held that an applicant for asylum is not time barred? In other words, that applicant can apply at any time and should be allowed to make application for asylum so that a refugee status determination officer can make a determination of whether that applicant is eligible or not for asylum. Do you accept that?
Yes.
That is what Ruta held. Okay.
Yes.
Now your case then is that Ruta has been subsumed or it has become redundant in the face of this legislation. So let's look at Section 21(1)(b) against that background. The section reads, an applicant who may not be in possession of an asylum transit visa as contemplated in Section 23 of the Immigration Act must be interviewed by an immigration officer to ascertain whether valid reasons exist as to why the applicant is not in possession of such visa. That's an asylum transit visa. Now my question is this, the first one. I've got a few, but the first one is this. Do you say that this section bars an illegal immigrant from applying for asylum? It's an absolute bar. And if so, I want you to explain to me why. Where in the section does it say so? How do you read the section to say so? That's my first question.
Justice Madich, it is not a bar. That is not the respondent's submission. What the section, the respondent's understanding of the section is that the applicant is not automatically entitled now to be released and to apply. What that section requires is that now the immigration officer, unlike before, now has the authority to question the applicant on why they are not in possession of that asylum transit visa.
Okay, I understand that. Thank you. I understand that. But now just practically, let's just work this out. Mr. Abore is sitting in Landela and Krugersdorp.
Mm-hmm.
How does the immigration officer make that determination? How does he go to Mr. Abore? Must Mr. Abore be taken to him? How does that work in practice? That's I think following on what my brother Rogers asked earlier. And that is what I don't understand about this new regime. Can you explain to me how that works in practice?
As I have explained, Justice Madich, that in this recent Pretoria High Court decision, Kolapen J there says that the respondent has to find a way to comply with that section 21(b). Either the officials visit the aspirant asylum seeker where they have been detained, or they make arrangements for them to come to the refugee reception offices for that interview to take place.
Right. So if that is the case, then how do you reconcile that procedure with Section 21(4) of the Act? Now that's part of the old Act which was left unaltered. That Section 21(4) says the following, and I must immediately qualify that it presupposes that an application has been made for asylum. Section 21(4) says, notwithstanding any law to the contrary, no proceedings may be instituted or continued against any person in respect of his or unlawful entry into or presence within the Republic, if such person has applied for asylum in terms of subsection 1 until a decision has been made, and so on. So where does that leave Mr. Abore? He must wait for the immigration officer to come to him and find his reasons for not being in possession of that asylum transit visa before he can do this application and before he can have the protection of Section 21(4). Is that how you say it works now?
That is what the Act says, Justice Madid, that the protections of 21 sub 4 only come into play once the application has been filed. Until such time, then the applicant is not entitled to all those protections. And it's our submission that it will not be the end of the inquiry. Let's assume that the immigration officer decides that the applicant has not shown good cause and therefore refuses them to apply. The applicant still can review that decision. We have processes on how to deal with administrative acts that affect people's rights. So it's not like the applicant then will be deported immediately. The applicant still has some remedies to review that decision, and the court then can intervene and then look at whether the official applied their minds, go through all the processes of administrative law and make a determination.
All right, thanks. It doesn't really satisfy me, that answer, but let's move on, because I don't want to take up too much time. The last aspect that I want to deal with is something that you touched on, and that's Regulation 8.3. And again, the regulation, and you mentioned good cause, it comes from Regulation 8.3. It reads, any person who upon application for asylum fails at a refugee reception office to produce a valid visa issued in terms of the Immigration Act must, prior to being permitted to apply for asylum, show good cause for his or her illegal entry or stay in the Republic as contemplated in Article 31(1) of the Convention. Now, I want to turn to that article shortly. I first want to make the point. Do you accept that we can't use a regulation? We can't let the tail wag the dog. In other words, we can't use this Regulation 8.3 to try to interpret what 21(1)(b) means. Do you accept that as a principle of law? First. Must I repeat it?
Can you just, I was trying to understand your question properly.
Let me go slow. I'm saying as a general principle of law, we can't have the tail wag the dog. In other words, we can't have, I'm saying that we can't have recourse to Regulation 8.3 to try to interpret what Regulation 21(1)(b) now means, this new, what the new section means, 21(1)(b) means. Do you accept that?
Yes, Justice.
Yes. Now, Regulation 8.3 refers to Article 31(1). And Article 31(1) does not deal with a bar. Good cause cannot be interpreted to be a bar to an applicant like Mr. Abore to apply for asylum. I say that because Article 31(1) reads as follows. The contracting states, and South Africa is one of them, shall not impose penalties on account of illegal entry or presence on refugees and so on, provided they present themselves without delay to the authorities and show good cause for the illegal entry or presence. So good cause in that context doesn't mean it's a bar. You cannot apply for asylum until you have shown good cause. All it says, you can't impose penalties. Do you see where I'm coming from, Ms. Nobanda?
I hear you, Justice, but I don't understand your question exactly.
Let me try and rephrase it. It seems to me that you rely on Regulation 8.3 as a bar, as an absolute ban, until a potential refugee has shown good cause why he or she is not in possession of that asylum transit visa. They can't have an interview. They can't be considered for an asylum application. Is that your case? Unless I misunderstand your case.
That is our case, Justice.
So good cause is a basis for an absolute bar. And I'm saying to you, you can't have that because Article 31.1, which the regulation itself mentions, doesn't refer to an absolute bar. It refers to a contracting state shall not impose penalties. Do you accept that there's a difference?
I do, Justice, but I would not say it's an absolute bar as such. And our contention is that should the applicant be refused application, there are still processes that the applicant can use to review that decision, not to allow him to apply.
Yeah, Ms. Nabanda, I'm going to conclude by just saying to you from where I'm sitting, prima facie, and unless I'm persuaded otherwise, and I'm open to persuasion, it seems to me that Regulation 83 cannot be interpreted and cannot be applied in the manner that the respondents seek to do in this case, because that would infringe our international obligations in respect of Article 31.1 and Article 33, which is the article which establishes the principle of non-refoulement. I say that because if this regulation purport to undo what Ruta and this court held, it would infringe the principle of non-refoulement, and it cannot apply in the way you want to, because it doesn't constitute an absolute ban. It simply says contracting states shall not impose penalties against applicants such as Mr. Abore. That's why my difficulty lies primarily in this case.
I'm sorry. So I'll give you, Ms. Nobanda, the tea break to consider your response to Justice Majid. So we are going to take the tea adjournment. It's 17 minutes past. We'll resume at 11:30.
Yes, thank you, Chief.
Thank you, Chief.
So this has been removed, so it's been changed, this whole section 21. Refugee Act, there it is. So they made a 21 and 21A and a 21B.
Okay, okay. And when you prepare my files, also bring me
Kelly, I have your hug, please. I'm sorry.
Acting Chief Justice and Justices, all counsel are online.
Ms. Nobanda?
Thank you, Acting Chief Justice.
Yes.
The question that Justice Madic asked on whether now there is a bar on the application, on reading that subsection, and I'm more reluctant to argue it further on the basis that there hasn't been sufficient time for the courts to deal with this regulation and to see how it applies in practice. And that is one of the reasons, justices, why the respondents were saying that this matter should not be before this court until these regulations and the amendments have been fully developed and interpreted by the courts. We don't even know how it's going to unfold as time goes on, how the courts are going to interpret this section, whether it's an absolute bar or it's not. But at this moment where we are now, it's fairly new that we are not even aware how the courts will interpret it. So that would be my submission.
Sorry, Mr. Banda, I can understand your discomfort, and that's why I asked Mr. Vobi earlier, shouldn't this matter make a turn in the SCA first? Because look, I must tell you, Mr. Banda, I've just read Colopin Jay's judgment in the tea break. And it does concern me where he holds at paragraph 27D. He understands the position to be as follows, and I'll just read it out because we haven't had a look at this yet. Colopin Jay says in the Abraham case, which you referred us to, he says Regulation 8.3, however, provides that those who fail at a refugee reception office to produce a valid visa issued in terms of the Immigration Act must, and this is the part that bothers me, must prior to being permitted to apply for asylum, show good cause for his or her illegal entry to stay in the Republic as contemplated in Article 31.1 of the 1951 Convention. Now, that does bother me because that seems to indicate that the learned judge reads that to be an absolute bar. You cannot apply because Ruta says you can apply. You must be able to apply. That's what Ruta says. Following on all those other cases, Abdi, As, and Ershumo. Now, Colopin Jay says you must first show good cause for not being in possession of that visa before you can even apply for asylum. So I've grave difficulties with that. But as you say, at this stage, it's new ground, and I must say I would have thought that perhaps this matter should have gone to the SCA on an urgent basis first. But that's prima facie. Thank you, ACJ. I have nothing further. Thank you, sir.
Thank you, Ms. Nobanda. Would good cause in those circumstances include the circumstances which would
Chief Justice,
support...
Acting Chief Justice, can I interrupt? I'm sorry,
Yeah.
I think I lost connection at some stage, so I didn't hear
Oh,
part
okay.
of, yes.
Okay, you can hear me now.
Yes, I can hear you, but I didn't hear Justice Madid, what he ended up saying.
Oh,
Justice Majid, you want to?
I don't know where you lost me. All I was saying is that did you hear me talk about paragraph 27D of Kolopinjay's judgment? You heard that part?
I heard you said it concerned you, and I was still
Yes.
listening now to your concern, and then I think we got cut off.
Oh, just to summarize, I'm not going to go through the whole thing again because of time, but the whole thing that concerns me is that Kolopinjay seems to hold that prior to being permitted to apply for asylum, an applicant must first show good cause for not being in possession of that visa. And I'm saying it's of concern to me because that conflicts directly with Article 31.1, which, mind you, Regulation 8.3 refers to. And so I said, it seems to me that because this is new ground, it should have gone to the SCA first on an urgent basis for that court to give guidance and so on. But that is all I said. Thank you.
Thank you, Justice.
Are you able, Ms. Nobanda, to indicate what in your submission would be some of the circumstances that would fall within the ambit of good cause that is required in that situation?
I did try to think about it, Acting Chief Justice, but it was, I was just thinking in terms of usually the normal facts that maybe the applicant, the aspirant applicant has been in the country for quite some time and they haven't done anything, to apply, and they only evince that intention when they get arrested, as it was decided in the previous cases, that they can use now that the issue that they want to apply for asylum, and now that probably then the immigration officer will probably have to look at the circumstances of that case, how long the applicant has been here. And I don't know, I try to think, and that's why, Justices, I thought that this matter would have been best served in the SCA after, when different circumstances arise, and see how now this regulation and the amending section applies. Because so far it seems that the applicants, they are still relying on regulation 2, subsection 2, where they should, once they evince that an intention to apply, then they are just released from custody and be allowed to apply. Like it's an automatic right to get out of jail and be given a permit and apply. So and that is the respondent's concern, that for this court to hear this matter at this early stage of the regulations, where different scenarios haven't played out in the courts, then it would actually be shutting down now the development of now the jurisprudence on this new amended sections and the new regulations.
You see, Mr. Nobanda, I understand an argument that says, certainly from the court side, that says it would be in the interest of justice for us to have the benefit of the views of the Supreme Court of Appeal on these new provisions. That I can understand, but I can't understand an argument that you, being the respondents, you don't know what good cause means. These are your instruments as the respondents. How can you, and it's not going to assist you to say the matter must go to the Supreme Court of Appeal to have an answer to the question. Because what Justice Majid was putting to you was, what is the position of the respondents? What is their submission on what this means? And of course, I added to say, what is contemplated under good cause? At least the respondents should be able to say, this is what in our submission is contemplated. Because even if the matter were to go to the Supreme Court of Appeal, the same question would be put to you, Ms. Nobanda. and what would you say then? You'll say, well, we'll see when we get to the Concord. Maybe by then we'll have an answer. Ms. Nobanda, it looks like she's frozen.
I think we have lost connection with Ms. Nobanda, Acting Chief Justice.
Yes. Would Zunaid be listening and watching? And
it looks like she has reconnected.
Oh, she has reconnected.
You are on mute, Advocate Nobanda.
Thank you, Justice Brown. Yes, Acting Chief Justice.
I don't know if you heard everything I said, or did you hear the substance?
I heard that it doesn't assist the respondent on what would entail good cause, that we should go to the SCA if we don't even know what good cause is.
Yeah, so in other words, what I'm putting to you is that it's not a ground for us to say this matter must go to the SCA if you say, as the respondents, you don't know what is entailed in good cause. But it would be an argument to say, well, this court, it's in the interest of justice for this court to get the benefit of the views of the SCA. But you should be able, as the respondents, to say, in our submissions, this is what it means.
Yes, as I was saying, Acting Chief Justice, that I believe it will depend on the circumstances of the case, and that's why I made that example of an aspirant asylum seeker who's been in the country for quite some time, and they didn't say anything about wanting to apply for asylum, and only raises it after they got arrested. That now our submission would be the immigration officer will now have to weigh the truthfulness of the applicant's intention, whether they always intended to apply for asylum or it is just an excuse that they are coming up with.
But then that would mean, if that is correct, if that is what is part of what's supposed to be done in that interview, what it would mean is that what would have been assessed and weighed and evaluated in considering the application for an asylum is now weighed and assessed at an earlier stage, isn't it? If what you are saying is correct.
I believe, Acting Chief Justice, that it would not be on the legitimacy of or the bona fides of the reasons for the applicant to apply, but it will be only superficial on the basis of if this person really came here to apply for asylum and they've been here for such a long time without applying. Is that a reason? Is it genuine or not? Without going into the truthfulness of the application itself, but superficially now on the procedures.
Okay, continue. If there are
Acting Chief Justice,
questions.
may I just follow on from what you've been raising? In regard to good cause, what Regulation 8.3 says is good cause as contemplated in the convention. So one would probably need to understand what is the concept of good cause in the convention. And if we read in Article 31.1, I think Justice Majid already has put it to you, but it says certain things can't be done by contracting states to refugees, provided they present themselves without delay to the authorities and show good cause for their illegal entry or presence. In the context of that article, it presupposes that the person has presented themselves without delay. So whatever good cause means, it can't be good cause for having delayed in presenting themselves. It must bear on something other than how long they have been in the country. Have you investigated or considered whether this article and the meaning of good cause has been the subject of any international jurisprudence?
No, Justice Rogers. But I think from your explanation or from reading the article, that is the example that I was trying to give to the acting Chief Justice, that if we were to use that example of someone having been in the country for that long, and now then they want to apply for asylum after they have been arrested, I think it touches on that.
Well, what I was raising for your consideration was that since good cause in the convention is a separate requirement from the fact that the person should present themselves without delay, it appeared to me that good cause, whatever it means, is not concerned with how long the person has been in the country for. But I think you've made your submission.
Thank you.
Ms.
Mr.
Nabanda,
Banda, sorry, I just want to, there's something I omitted to ask. Sorry, my sister, Acting Chief Justice, I know I said I was finished, but there was an important aspect that I forgot to ask right at the end. Mr. Banda, can you help us? As I understand it, Mr. Vobi told us earlier that Mr. Abore has been released from detention because the 90 days had expired. Is that correct?
Yes, Justice.
And after his release, what has transpired? Was there an attempt to deport him, or you don't know?
From what I saw on the applicants, we haven't had the opportunity to hear from the department, but the applicant in his heads of argument appears to say that they tried to deport him. And then
there was an application, an urgent application to interdict
from the High Court.
Yes. Well, and that's the point I forgot to ask you. I mean, it wasn't in the papers, but I saw it somewhere, and you reminded me it's in the applicant's heads. And that does concern me, because if that is so, and I understand that you haven't had instructions, please don't misunderstand me. I take the point that you haven't had instructions. But assuming for the moment that that's correct, it means that subsequent to his release, notwithstanding your interpretation of the amended section 21(1)(b) and regulation 8.3, the new regulation, notwithstanding your interpretation, it means that the department was going to deport Mr. Abore even before he had an opportunity to be interviewed, whether that interview takes place at the offices of the Refugee Reception Determination Officer, wherever it may be, or at the prison, or at Lindela, at the repatriation center. That does concern me, because it makes a mockery of your interpretation of the act. It means that he would have been deported without being given an opportunity to apply for asylum. And that's exactly what Ruta and many other cases, Abdi, Sumo, and so on, and more importantly, the convention says contracting states should not do, and that is what deeply concerned me, and I must raise it with you.
Yes, and I understand, and your concern, Justice, and also from our side, as I've already indicated to the court, we are not even briefed on that matter. So we also saw it for the first time in the applicant's heads of argument, and we haven't had any instructions now regarding that. But that is as far as I can respond to this. But we do accept your concerns in that regard.
Ms. Nabanda?
Yes,
Justice
Justice Taron.
Thank you, Acting Chief Justice. I know some of my colleagues have covered section 2, but I just want to be clear on what the respondent's position is. Section 2 of the Refugee Act expressly states that it applies, and I quote, notwithstanding any provision of this act or any other law to the contrary. Does the respondent accept that Regulation 8 of the amended regulations cannot override section 2?
That's correct, Justice Theron.
Now,
because it's only a regulation.
Yes. Now, Justice Majid also touched on this. If the applicant is deported without being able to make an application for asylum, what would the effect of the High Court judgment be? My second question would be, how would we know that he's not going to face persecution or threats to his life or physical safety or freedom in his home country? And if we can't answer those questions, if we don't know what the position would be he would face in his home country, would the deportation not be in breach of the principle of non-refoulement?
And Justice Theron, I would just be, I believe that hypothetically, if that should happen, it would be contrary to a section 2 if he is deported and we don't know what's going to happen to him. But all that I can say is these regulations are supposed to guide the respondents in dealing with these applications and the procedures that the aspirant asylum seekers have to comply with in terms of the amended act.
Now, let's just go to Ruta for a minute and the principle that emerges from Ruta. Is the respondent's position that the Ruta principle no longer applies because of the amendments?
Our submission would be only to the extent that Ruta, in confirming the quartet of cases from the SCA, that in interpreting regulation 2 sub 2, the applicant is entitled, and I say entitled, underlined, to be released if they're in detention and be issued with a permit valid for 14 days and be allowed to apply for asylum. To that extent, the new regulations, now they've done away with that automatic right to be released. And that is only to that extent.
Now, Ms. Nobanda, I don't understand how the new regulations can dilute the Ruta principle. Ruta was decided on the basis of section 2 of the Refugees Act. That section has not been amended. It seems to me that Ruta would still stand. Ruta was not decided based on the regulations or any other sections of the Refugees Act. Ruta was based purely on section 2. The ratio in Ruta is that by virtue of section 2, the shield of non-refoulement may only be lifted after a proper determination of an asylum application. And that was based on section 2. Section 2 has not changed. So I'm not sure on what basis the respondent would contend that the Ruta principle has been diluted.
Justice Theron, as I have indicated earlier, Ruta also confirmed the quartet of cases in the SCA, particularly Bula, where it stated that the starting point would be Regulation 2 sub 2, which requires that the aspirant asylum seeker be released from detention if they are detained, irrespective of when they evince that intention to apply, and be allowed to apply and be given that permit. So the respondent's submission is that only to that extent, if you recall, Justice Theron, the applicant is saying he's entitled to be released from custody and be issued with that permit and be allowed to apply. Now, what the respondent is saying is that was only applicable in line with Regulation 2 sub 2. But since there is no, that regulation has been repealed, and there is no regulation which now it's equivalent to Regulation 2 sub 2, the release from detention and the applicant being allowed to apply, it's no longer automatic. Now the applicant has to comply now with the applicant in the position of the applicant in this case, to comply with a Section 21 and Regulation 8 sub 3 or sub 4.
Please continue.
Oh no, I was done. I was just trying to just reiterate that the respondent are only saying that only in that regard for the order that the applicant is seeking to be released from custody. Only to that extent, the router has been superseded now by the amendment and the new regulations.
Yes, and I know I've made the statement, but router was not based on the regulations. Router was based on Section 2, which has not been amended. But let me come to Section 1. You've mentioned Section 1, Advocate. No, sorry, Section 21. If we assume that the applicant entered South Africa before January 2020, would the respondent agree that he was vested at that stage, before when he entered in January 2020, with the right to apply for asylum in terms of Section 21 of the Refugees Act, and a right to a 14-day visa in terms of Regulation 2.2, and the right not to be deported until his asylum application was determined?
No, Justice Theron, the respondent totally dispute that. The respondent's submission is that the applicant only evinced his intention to apply for asylum at the earliest, now according to the papers before court in the Durban High Court, and that was sometime in July 2020. And at that time, already the new regulations and the amendment has come into effect. So therefore, the respondent cannot, the new regulations and the amended act were triggered by the applicant's intention to apply. And at that time, and if you recall, Justice Theron, from the pleadings, the applicant was arrested in June. And the respondent's submission is that even when he appeared before the magistrate, where he pleaded guilty to being in the country illegally, he never mentioned that he wanted to apply for asylum. So even if he had mentioned it at that time, already the new amendments have already taken effect. So therefore, that it is incorrect that the amendments are not applicable. Let's take, for example, Justice Theron, if the applicant now has been in the country for 3 years, and probably maybe, let's say 2017 or whenever, but then the applicant gets arrested later in June 2021 or 2020 after the amendments have come into effect. How would then the applicant then raise that they fall under the old regulatory framework when they didn't do anything during that time, that before the amendment came into effect? Then it would lead to like ridiculous conclusions that because they came here 5 years ago, then but only evince that intention to apply for asylum after the new amendments, and then claim that the old regulations are applicable. Our submission is that that would be not feasible and it would be untenable.
Thank you, Acting
You
Chief
done,
Justice.
Justice
Thank you,
Theron?
Acting Chief Justice. Thank you.
Okay, all
Thank
right.
you.
If there are no questions from my colleagues, can I ask Ms. Nobanda whether those would be your submissions, or I know we have gone beyond the 45 minutes, but we asked you questions, or is there any important issue you still wanted to deal with?
No, Acting Chief Justice. As you had explained earlier, that
Yes.
our heads of argument and we still
you stand by them.
We stand by them.
Yes.
Thank you,
okay.
Acting Chief Justice.
Okay. Then I would now call upon Mr. Vobi to address us in reply. I'll give you 15 minutes, Mr. Vobi.
Thank you, Acting Chief Justice. I will be very short in reply.
If you say you will be 5 minutes, we'll take that as well.
I will take 10 most.
Okay, all right.
I will start with the judgment of Shanko Abrams. Unfortunately, I appeared on the matter. The matter was on the basis that the applicants have arrived in the country in 2020. There was no dispute about the new regulations or the old regulations. We went to court to seek an interdict that they should not be deported and they be given an opportunity to apply for an asylum. Then the court had to decide whether there is a good cause that has been shown, and the matter was decided on the basis of Regulation 8.4. The court accepted that there is a good cause that has been shown. However, the court refused to release the applicants. It decided that they should be assisted while they are in detention, and then after be released after they had obtained the permit. However, in respect of the second part of the order, we are still taking instructions because the judgment was delivered last week. I argued about 2 matters, there were 3. So that's the position in respect of the judgment of Shanko. It was clear the argument was about the new regulations, not whether it should be decided based on the old regulations or not. In the present matter, it's different from what was decided in Shanko and Abrams, on the basis that we argued the matter in the High Court relying on the old regulations. So we submit that there is no need that the matter ought to have been referred to the SA, because this argument of the regulations, it's not the argument that was presented at the High Court. There is no way that would have known or anticipated that there would be a challenge on the basis that the SA will first have views on the new regulations. In fact, even in this court, in the answering affidavit, the point is not raised.
Mr. Vobi, I'm going to interrupt you because I see you are repeating something that you said earlier on in your address, namely that if the issue of regulations was not raised in the High Court, that that is something that you can rely on to answer the argument that it is in the interests of justice that you should have gone to the SCA first. Those are two different things. The argument that was raised by the respondents in relation to the SCA was really whether it's in the interest of justice that you be allowed to bypass the SCA. Now, the amendments apply whether they are raised or they are not raised. They apply if they apply, they don't apply if they don't apply. Doesn't depend on whether they have been raised or not.
Thank you, Acting Chief Justice. In fact, I understood the argument that the reason they argue that we ought to have gone to the SA, it was on the basis of the new regulations for the SA to first make a view on that. However, I will move forward just to—
No, they say, as I understand them, it's in the interest of justice that you should have gone to the SA first, and then they say the SA would get a chance to deal with the amendments and with the amendments. But as I understood you, certainly earlier on, you were saying that the amendments were not raised and therefore were not applicable, and you were bringing that in terms of the SCA argument.
Yes, Acting Chief Justice. That's why I said after I will move forward, because I've made the point already.
Okay,
just
all right.
in the interests of justice, we also vehemently rely on the judgment of this court, which is the judgment of Minister of Home Affairs and Tsebe, which is in fact, in that judgment, we rely on paragraph 21, 23, and 25, which covers the issue of the interest of justice as to why we have appealed direct to this court. Then my last point will be in relation to the status of the applicant when he was released. In fact, what happened on the 25th, he was issued with a notice to depart on his own. He was given up until the 25th of July to depart, and that if he doesn't depart, he would be arrested, detained, and to be deported. So it was necessary to approach the High Court to obtain an interdict pending the finalization of this application, which goes against the argument that we ought to have gone to the SCA when the matter was urgent, because it was urgent to come to this court. And despite this matter being pending before this court, however, they made another constructive deportation, which they issued a notice. So I submit that those are our submissions in reply, and that we should succeed with costs.
Thank you very much, Mr. Vobi. There are no questions from my colleagues. I don't see any questions. We are going to therefore stop here. Judgment is reserved and the court adjourns.
Thank you, Chief Justice.
Thank you.
Today's proceedings have concluded, and now the host will accordingly terminate the meeting.